As Catherine Hunter is unable to be here, but Steve Sturdy, who's the Deputy Director of the Genomics Forum and also Director of the GenGage programme, is going to speak on Catherine's behalf. So well done, Steve.
When Catherine sent her apologies for not being able to be here, she had a teaching commitment that came up quite suddenly, but she has sent through a very full set of slides outlining the legal situation, the legal regulation of tissue donation, tissue banking and organ donation and banking in Scotland. And I'm simply going to run through very quickly her slides and highlight the sort of key features of the regulation of organ donation, including brain donation in Scotland. There's a lot of information on these slides. You're not going to be tested on it. This is really just to quickly fill you in on what the situation is. If you want to follow this up, we will be putting these slides up onto the GenGage website, so you can go back and refer to these at a later date. But I'm just going to, as I say, whiz through now and tell you where we stand in Scotland. So, first up, the legislation governing human tissue in Scotland. The relevant bit of legislation is the Human Tissue Scotland Act of 2006, which regulates the removal, retention and use of tissue from the deceased for transplantation and or for research, and from the living for transplantation purposes only, so not for research. So Tracy mentioned that some of the material that comes for brain research is from surgical biopsies, for instance. That's not actually covered by the regulation. This is an interesting difference from the situation in England, Wales and Ireland, where the relevant regulation is the Human Tissue Act 2004, and that includes tissue taken from post-mortem examinations, but also from living patients. So there's an interesting gap, if you like, in the regulation in Scotland, and quite how that's come about, I'm not entirely clear. One thing that I will come back to again at a later point is that one bit of the English and Welsh legislation, the 2004 Human Tissue Act, that does apply in Scotland, one particular clause relates to the use of tissue for DNA analysis. And DNA, this clause which prevents DNA analysis from tissue without consent, also applies in Scotland. So there's an issue of what's called DNA theft. I'll come back to that in a wee while. But the important thing is that there is regulation that governs in Scotland post-mortem use of tissue, how it may be got and how it might be used. A little bit more also on the relevant authority. In England, Wales and Northern Ireland, there is the Human Tissue Authority, which was created by the 2004 Act. And that authority, that panel, has responsibility for overseeing the uses of human tissue for research, for treatment, for post-mortem examination, for teaching and exhibition in England, Wales and Northern Ireland. The Human Tissue Authority doesn't have any remit in Scotland apart from overseeing the use of tissues for living organ donation. So it doesn't have any remit for research purposes. The Human Tissue Scotland Act deals with three distinct uses of human tissue: donation for purposes of transplantation, research, education or training and audit, the removal of human tissue, its retention and use following a post-mortem examination, and for the purposes of the Anatomy Act, this is about use of the donation of bodies to medical science. It requires authorization for the use of tissue samples for research unless they're existing holdings. So any new donations have to be, for research purposes, have to be authorized. And I'll say a bit more about authorization in a minute. Donation for research. Under the 2006 Act, a person may authorize the use of his or her body parts, organs, tissue, samples or blood for research in the context of organ donation and transplantation or hospital post-mortem examinations. So these are within the medical context, if you like. We've also heard from Tracy about the situation for tissue samples held by the Procurator Fiscal. So this is in cases where there's required to be a medical legal investigation. So cases of sudden death in particular. Tissue samples may be used for research with appropriate authorization. And Tracy has told you something about the process by which authorization is obtained in Edinburgh. And just to emphasize the force of this legislation, it is an offence punishable by a term of imprisonment, fine or both, to retain or use a body part obtained after the passage of the 2006 Act for research purposes without the appropriate authorization. So authorization has to be obtained for the use of human tissue obtained from post-mortem for research purposes. Authorization. I've said that this is the key principle of the Human Tissue Act, Scotland, 2006. It's intended to convey that people have the right to express during their lifetime their wishes about what should happen to their bodies after death. It also strengthens, and this is important, the system of opting in. The idea is, the older legislation simply allowed tissue to be used for research purposes if there was a lack of objection. The 2006 legislation now requires that people opt in to the use of their tissue for research purposes by providing explicit authorization. And authorization in the Scottish context is effectively equivalent to consent in the 2004 English, Welsh and Northern Ireland legislation. Post-mortem examinations. In the 2006 Act, post-mortem examination means any examination of the body of a deceased person which involves dissection and the removal of organs, tissue samples, blood or any other body fluid, which is carried out for any or all of the following purposes: providing information or confirmation about cause of death, investigating the effect and efficacy of any medical or surgical intervention carried out on that person, so effectively to review the outcomes and the effects of medical interventions while that person was alive, obtaining information which may be relevant to the health of any other person, including a future person, and audit, that's basically clinical medical audit, education, training, or research. Who can give authorization? This is an important issue, and one that you may well be discussing in the discussion session coming up. The carrying out of a post-mortem examination and the retention of tissue and organs thereafter can only proceed if proper authorization has been obtained. And authorization may be given either by the person before their death, or by a nominated representative, or by a relative. In the case of self-authorization, an adult may authorize a post-mortem examination of his or her body after death, and by virtue of the authorization for the post-mortem examination, any part of the body may be removed from the body during the post-mortem exam and can be retained and used thereafter for any of the following purposes: transplantation, education or training, audit, and or research. And this covers particularly tissue samples, blood or bodily fluid, which removed at post-mortem. This becomes part of the patient's medical record and can be used for research without further authorization. So simply by authorizing a post-mortem examination, then tissues removed at post-mortem can then be used for research purposes. So in effect, by authorizing a post-mortem exam, you also authorize research use. There is a slight difference, though, as regards whole organs. The retention and use of whole organs for the purposes of audit, education, training, or research requires separate authorization from simply tissues. Whole organs have to be separately authorized, and this must be obtained in writing and signed, or it can be expressed verbally in the presence of two witnesses. And having made that authorization, that authorization may then be withdrawn in writing or verbally in the presence of two witnesses. A nominated person, an adult, may also, as well as authorizing things themselves, they may nominate one or more persons to represent them after their death with respect to authorizing a post-mortem examination, the removal of an entire organ, so again this issue of the separate issue of whole organ removal, and the retention and use of an organ for research, audit, education, training, etc. And again, a nomination must be in writing, it must be signed in the presence of a witness who's not the nominated person. The third option for authorization was family members, and where the person hasn't given their own authorization or nominated somebody to authorize on their behalf, then there's a list of family members who can be approached to provide authorization in order. And this is in order effectively of closeness of relationship, so you can run down the list yourself and see who can be approached. There is no specific form for self-authorization of a post-mortem, but the NHS has produced a post-mortem authorization form for nominated representatives and family members. And if you want, when this becomes available, you can, when these slides go up, you can go and look at this yourself. And the form contains tick boxes for the authorization or retention of whole organs, including the brain, for distinct purposes. So you can choose whether or not to tick which of these boxes: diagnosis, audit, education and training, research, and genetic research. That inclusion of a separate tick box for genetic research is important because, as you'll recall, that there is a separate clause in the 2004 English and Welsh legislation that refers to the question of genetic research. So genetic research has its own separate authorization. And this, just to strengthen this, there is, under the 2004 legislation, a separate offence of DNA theft, which is the use of bodily material or the holding of bodily material with an intent to analyse its DNA without specific consent for that purpose. And again, there are strict punishments to be applied if that is breached. Consent is legally required for DNA analysis from a deceased person, also for tissue collected after the 1st of September 2006, and explicit consent for DNA analysis is required in Scotland, although this is under the English legislation. Who can consent to DNA analysis? The person themselves can consent prior to death if they're considered competent. This doesn't have to be in writing. If it's given verbally, though, it should be documented for evidence. If the person hasn't, this is actually running over, I think, something that was discussed before. If the person hasn't provided explicit consent prior to death, anyone in a qualifying relationship, next of kin in effect, can give consent. Or also in respect of an adult who lacks capacity to consent, a welfare attorney or guardian appointed under the Adults with Incapacity Scotland Act of 2000 may also provide consent, authorization. If you wanted to donate your brain or brain tissue after your death, the best thing to do is to make your wishes known early. Unfortunately, there's no current brain donation program existing in Scotland, and so brains for research can only be retrieved in a hospital autopsy suite or from a medico-legal mortuary. There is no specific self-authorization form for brain donation. So if someone wishes to donate their brain for research, this should be done ideally in writing, and it should specify the purposes for which authorization is given. The more explicit this is, the better. So diagnosis, audit, education and training, or research. And also, separately, if you're prepared to have your tissue used for DNA analysis and genetic research, this too should be explicitly authorized if this is what you want. Even if you've given this, it says here, the nominated representative or closest family member will still have to complete the hospital post-mortem authorization form. So wishes about brain donation should therefore also be made known to family and friends, nominated representatives, GPs, and if appropriate, executors.